I am Qiana Manns of Manns Law Offices PLLC, and I am so excited for you all to join us on today. If this is your first time, welcome, welcome, welcome. If you have been along for this ride, then you already know you're in for a treat. But today is very special because my co-host and I both were born in the month of October. So we're about to day, and I got my sisters with me as well that are going to come on, and we are going to try to battle and tackle some of these family law questions that we get on a regular basis. And you all, most of you all have the same types of questions over and over. So we're going to get at them today. And so the topic for today is family feuds, tackling the common questions in family law and child support issues. And so I am passionate about family law, and it is at least 75% of my practice and what I do, but I have some lawyers, some sister friends, some colleagues who are going to join me today, and you will be in for a treat. But I'm going to introduce to some and reintroduce to other, my colleague, the person that I have dragged along, not kicking and screaming, I already told you that story, but I did drag him along with my idea of starting this webinar series for my legal services anniversary for my business. And he has been just a joy and a definite help. And I am so happy that he is still on board and he's taking this ride with me. So let me introduce you to Athill Muhammad. Athill Muhammad has dedicated his practice to endeavors of family, federal employment discrimination, civil rights matters, and representing persons accused of crimes in both federal and state courts, as well as representing clients in proceedings and hearings with various federal and state administrative agencies and entities. He is a dedicated legal researcher and writer on federal and state civil and criminal written appeals matters, including concerns to the United States Supreme Court, the Texas Supreme Court, and the Texas Court of Criminal Appeals. In addition to the State Bar of Texas, he is admitted there. Mr. Muhammad is also admitted to practice before the United States Courts for the Southern District of Texas, the United States District Court for Eastern District of Texas, and the United States Court of Appeals for the Fifth Circuit. He volunteers like he's doing for me and for us today with numerous organizations, and one of them is the NAACP. And I have to say that one because he gets all the calls and he does a lot of volunteer work with them that I had to tell him, don't put me on the list, brother, don't put me on the list. But I am so happy that he continues to serve with me and to be a part of this legal webinar series. And I always have to say that he may, turn his accent. So y'all won't be surprised, like you say, he was just talking regular, but he'll flip on an accent. So, just get ready for it. And we have some beautiful women that's going to be on our panel today. And so, it may just come out. But so I am wanting you all to put your hands together and welcome back our co-host for this webinar series, Athill Muhammad, who's going to help introduce some of our panelists today. And this is a party. So you're going to see our panelists pop in and come in because they're here and they're volunteering their time and they're serving you today. And we're going to take questions. It's going to be hot today. Y'all always talk about me like, oh, you didn't get my question in. You didn't answer my question. So this is a gift for you. I'm dedicating today to answer all of your common family law questions. And let me put this disclaimer out here, brother, before you introduce these panelists. They are pros, they are experts, they are the best in their field, but they are not your attorney, okay? So we're not creating no attorney-client relationship today based on the information that you are receiving. We're giving guidance and we're trying to serve based on our experience, to the best of our ability, and direct you to, the legal ways that you can go. Not necessarily giving you any type of commitment to us or to, how it is that we're practicing in our field and in what we do. So there's no legal client relationship being connected. Don't say you watched this webinar series and my lawyer told me this. No, that's not it. But we do want to serve you on today to help try to give you some understanding and some information about family law and how it is that you can navigate your way through it if you are having a situation and you're dealing with a family law issue. So without further ado, Brother Athill, please start introducing our panelists.
Certainly. Good morning, or good afternoon, rather, to everyone. And I thank you, Sister Qiana, for those words, and hopefully I can live up to them as much as living up to and trying to ride on the coattails of one of our panelists, Ms. Rhonda J. Shanklin, who is an attorney and president and CEO of Success House, a Road to Recovery Success House, which is it is a road to recovery. See, I botched that up already. See, it's the women on the panel that's making me nervous, so bear with me. Professor Sessions, and I say that because she was one of my professors when I attended law school. And so I'm just honored to be able to introduce her. And as I said, about to say, she is a native Houstonian and resident of Fort Bend County and has been for over 20 years. She is married with 2 sons. She attended both Xavier University of Louisiana and Texas A&M University, receiving a BS degree in biology. She completed her Master of Public Health with a focus on health services organization at the University of Texas School of Public Health and received a JD degree from TSU Thurgood Marshall School of Law. She is owner of her law firm, Rhonda J. Session, attorney and counselor at law, PC, and has been practicing law for over 27 years, primarily in the areas of family law, criminal law, personal injury. In the last 3 years, she has redefined her family law practice to concentrate on her roles as amicus, mediator, and advocate in DFPS termination cases, representing children and parents. Through her advocacy in Children's Protective Services cases, litigating on behalf of both children and parents, she worked diligently to reunify families and defend children's best interests. It is with the backdrop of her educational background and particular work experience in mind that in March 2018, she pursued her purpose and founded Success House, a nonprofit residential treatment program with mission of which is to make a positive impact in the community by working to make families negatively affected by drug and or alcohol addiction whole, healthy, and successful. The Success House program mission also focuses on early intervention into the lives of abused or neglected children or children at risk of abuse or neglect to ensure a healthy start before they turn school age. Brothers and sisters, I'm presenting to you Ms.
Hello, everyone.
Thank you so much for joining us today. I think we having some storms or some things going on that's interfering, but we're going to keep it moving. I see my other colleague has joined us, Miss Nicole Bates. She is on with, now I'm going to try to do you some justice, sis, but your resume is, man, the law office of Nicole R. Bates. She is the Chief of Staff for State Representative Harold V. Dutton, and she is, go ahead, sis. She also was an adjunct professor at U of H for a period, She's worked for House Committee on Urban Affairs. She is in so many organizations. She's a Texas State Bar member. She's on the State Bar of Texas Family Law Section, Houston Association. I mean, all kind of stuff. She's a mother and a wife. And you don't want to, I'm telling you, don't want to be going up against her on the family law. We good now, but I did have the opportunity, we've had the opportunity to do some cases together. And she is just a phenomenal woman with so much knowledge and expertise in the areas of family law. So I thank you for joining us today. I was looking and posting, you always try to be attractive and market. And I was like, my sisters-in-law, which it is a very beautiful community that we have. And I started this webinar series to give our community information about professionals and how to obtain our services and to let us know that we have everything that we need. And I truly believe, I guess I am discriminating, so I'm gonna just be straight up in myself. But I think that the Black attorneys that I've had the pleasure of working with are some of the best attorneys that I've ever met, and especially in family law. I cannot say enough about the women, the females that I've had the opportunity to work with, to be mentored by, to go up against, right? And, sharpen my skills. And so I am just excited about today. Sometimes I have to bring myself down because I'll be so pumped up. But this is one of those areas for me that I really take to heart, because when you're working with a family in any regards, as far as child support, custody, anything, possession and access, right? It's the most intimate way that you can be involved in somebody's business, right? In somebody's lives, in people's lives. And so I take it very seriously, and the women that I've asked to be on the panel do as well. And so we have really created a sisterhood, I can say, in Harris County. And it is very beautiful to have women that do what you do with the integrity also that you have, and to be able to learn from one another and help one another. And so I was telling everybody, this is my birthday month, and I'm a Scorpio, and y'all know we show out, right? And this is also my brother's birthday month. So this is a special webinar where we're gifting to the people the best and the brightest in family law to answer some of their questions. And we're going to have other panelists coming on as well to join us. Like I said, it's a party atmosphere today because it's our birthday and we ready, okay? And so we're just gonna get started and our panelists are gonna come in, but I am so grateful that you all have, graced us today, because I'm always trying to see how we can better serve our community and how our community can benefit from those who are, well prepared and versed in what we do, and not think that, the ice is colder on the other side. And so without further ado, we're gonna get started and we're gonna jump into our first question. What do you all think? And these attorneys here have a wealth of experience, and we get together and we talk about, the different questions that come in. So I said, let's kind of do just an overall show. Y'all can get it all out y'all system and, ask the questions so we can answer them. And ladies, what do you think is the qualities that you should look for in a family law attorney when you're dealing with a situation, whether it be, child support, divorce, possession and access, adoption, any of that? What are the qualities and experiences and different things that you think that people should actually look out for when trying to hire or retain an attorney for this type of case?
Do you want us to just jump in and just ask?
Just jump in. Yes, just jump
Okay.
in.
So I guess for my perspective, I would probably say, look for someone who's not going to gaslight you. Look for someone who's going to be straight up with you and tell you, look, this is really what's going to happen in your case. I'm not going to sit here and promise you the world, the moon, the stars, and I'm not going to promise you you're going to get custody. But, you know, this is what I see based on the facts of your case. So you definitely want to get someone who won't just, you know, sell you whatever it is that you want to hear. And then you want to get someone that you trust and that you feel comfortable with and that you can confide in and that you at least feel has your back. That's my personal belief. Rhonda?
This is Diane. I agree with Nicole 200%. And I would also say that you need to find an attorney who's willing to fight for what you are asking for, not willing to fight for the sake of fighting.
Mm-hmm.
There are some attorneys who will go to the mat and will fight simply because that's what they do. You have to find someone who knows when to hold them and when to fold them based upon what you're asking for. You don't want someone who is hell bent on winning against another attorney simply because they have personalized the case. They need to focus on what you want.
Now she just
And
jumped
just
in
to-
there.
Oh,
She just came and jumped in there. I didn't even know she was here. Can you introduce my sister, please?
By
So
all means.
we can know who this beautiful, wise woman that is speaking to the audience. And I think she's going to allow us to see her in a minute. But I did not know that you were on, sis. And so let us give you a proper introduction and we will continue on with the program. Go ahead, Brother Phil.
That, of course, was Attorney Diane Curvey, who has nearly 16 years of experience representing individuals, business owners, and other professionals from East Texas to El Paso. She graduated cum laude and received a Doctor of Jurisprudence degree from Thurgood Marshall School of Law in May 2005. Attorney Curvey has handled almost 2,000 family law, criminal, juvenile, and probate matters. While trial court litigation is key to her practice, she also conducts mediations for other colleagues who have family law cases. This allows her the opportunity to resolve even more family law cases and to use her sound judgment to assist those who seek out her services. Most important is her large mentorship program that she created for young attorneys who desire to work as sole practitioners. She understands how difficult it can be to navigate the waters of family law and has dedicated her life to making the sole practitioner road easier for attorneys who follow her lead. She assists these attorneys with strategy, interpretation of the family code, negotiations with opposing counsel, and hearings, including trials. Her goal is to go out and do good, like Thurgood Marshall said. Attorney Curvey volunteers her time and resources on a weekly basis to represent parents with alcohol and drug addictions who are involved with Children's Protective Services. Her main goal is to provide mentorship and legal guidance for these families as they navigate this system in hopes of regaining custody of their children. Attorney Diane Curvey.
Thank you.
So that was that wise woman that you heard. Go ahead, Attorney Session. You wanted to add in?
I was just going to piggyback on what Attorney Curvey said in that you do want a zealous advocate representing your interests, but you don't want someone that is so zealous that they miss trying to resolve your matter in the most way that is beneficial to your family as a whole, especially when you have children involved. Sometimes people, attorneys may just focus on you and what you want, and they don't sit back and try to explain to you. I understand that you're mad at the other party, but you still have to keep in mind what's best for your children, because your children are half you and generally half the other party. And so you have to be mindful of that. And sometimes when attorneys are being so zealous representing their clients, they forget that their client has children that will be affected by these family situations.
Absolutely, because we're called attorneys and counselors at law. And so we definitely have to counsel you in the best way that we can, because we understand that these cases are very emotional. And we try to navigate through the emotion with the law, and definitely representing you all to the best of our abilities with what we can do under the law as it stands. But I can remember coming in as a baby attorney and people wanting to be, I want you to, snatch their head off. I want you to cuss off their attorney. I want you to, be all aggressive. I think I'm naturally aggressive and kind of come off because I'm passionate about this, sometimes a little rough. But as far as attacking people personally, and trying to demean other attorneys and professionals, that's not our way. And that's not necessary for you to prevail, for you to succeed in your family law case. And I think sometimes the clients have a misunderstanding. I see a lot of our non-melanated, colleagues in family law, sometimes they get the clientele because they're in court and they're being nasty, and they're doing all of this talk, and your client kind of wants you like, punch back, do this, do that. But I'm like, if you only knew, they talking a lot and not saying nothing. They're not pushing your case forward at all. And you're sitting here and you're going to get a bill for about $25,000 and lose because the judge is an attorney, right? Most of our judges have practiced for years, have been on the bench, and even if they have not practiced for years on end, they've handled family law, they know the law, and so all of this fluff and tough talk does not impress them. They're not impressed. And, once we go out and have coffee and stuff, we all in the background like, did you see that food? And you're thinking that they are really impressive, but they are not, because they're not pushing your case forward. And overall, I believe the attorney session was saying, it's not good overall for your family, because after I get out in attorney session, or Attorney Bates or Attorney Curvey and I get out and we, see each other in the hallway and go to lunch or whatever, you all still have to be together and be, having to deal with all of the stuff that you have to deal with. So we know, don't personally hate each other. We don't personally hate each other, but we do take your position in the law and work on your behalf to the best of our abilities. And as I was telling you before, I've had cases with these ladies, and once we're on the other side, we're on the other side. We putting on gloves, we're ready. But it doesn't take being nasty, right, to be able to win. So I want to emphasize that a lot, because we have that, because the emotions are so high in family law cases, that I think that needs to be said. And I'm going to say it, straight up, especially in our community, because we go to the other side thinking that, they talking all this big talk, and they, coming in here and they're going to be able to get me more than I can get. And it's just not real. It's just not true. So what are your thoughts? Does it help to be nasty and vindictive in these types of settings with other professionals, or handling a matter based on your experience? Does that help you win, or make you feel like you're getting the upper hand in any way?
So this is Diane. I think that my reputation at the courthouse is, man, that girl is always smiling. She's always happy. She's always so nice. She's always so polite. And one of my clients one time told me, why are you doing all that smiling at them? You shouldn't be smiling at them. You need to let them know you're mad. And I told them, I said, just because you see a dog's teeth, it doesn't mean he's happy to see you.
Right.
And they said, oh my God, you the devil. I'm like, yes, I am. Yes, I am. I said, let me do this my way. And, you know, I said, and you can learn from me. I don't ever burn a bridge that I'm going to have to cross over in my next case. This is a profession for me. This is not, I'm not just going to beat up your cousin on the playground because they offended you. This is my profession. And I haven't been doing this 16 years just so that I can, you know, anger every person that I've come in contact with. When I have a case against that other person the next time, they're going to say, man, you did a really good job on that. I was a little mad at you, but you did a great job. Let's negotiate this one. And that's the way that I look at it. I'm going to get you what you want, but I'm not going to lower my standards. I'm not going to lower my standards, and I'm not going to act a monkey in public for you.
Mhm.
You don't pay me enough.
Right. Attorney Bates, I saw you unmuted.
No, I completely agree with her. I don't think, you know, the conflict that you're trying to create some type of conflict there with another attorney or an opposing counsel simply because that's what your client wants is going to get them anywhere, or it's not going to get them more of anything that they want either. Sometimes, you know, taking that high road and learn or just working with the opposing counsel can oftentimes get your client exactly what they want.
Absolutely. You wanted to chime in there, Attorney Session?
I did.
Okay, go ahead.
I would say it's always best to remain professional, especially for some of us that we do more than represent parties. We represent children. We're mediators. So if you're the type of person that is so rah, 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 and so focused on just hammering the other opposing counsel, you're going to be in other roles. You're going to be in other roles where you're going to want those people to be sympathetic to your client, or you're going to be in a position where you're supposed to not be as a mediator, not for this party or that party, but a person that's a facilitator. No one wants to, after they've just been in a case with you where you were, you know, and then someone on another case says, well, let's use this person as a mediator. No, I just had a case with that person. That person is not even killed. That person is, you know, no, nasty attitude. No, I don't want. And then, or as an amicus representing the children, who wants somebody that's nasty and unprofessional looking out for the best interests of their children? Nobody wants that. And then when you're in CPS cases, you may represent a parent on one case, and in another case represent a child. So you have to realize our roles change. It is not beneficial for any of us to be unprofessional at all, you know.
And the louder you are does not mean that you have anything to say, right? I hear a lot of terms that are used sometimes, I guess, to impress the client, because the client don't really understand, you know, that's our role, to navigate them through the statute, and, you know, what your rights are and what you can do and what you cannot do, and how, if we can, get you to where you want to be. But I hear sometimes that there is a lot of talk by some family law attorneys just to impress, but they're not really saying anything. And I remember as a baby lawyer, and I still do it now, because my uncle, y'all know so much about me. I tell my viewers too much, right? I told them they just go ahead and adopt me at this point. My uncle, who, you know, I have one of those jailhouse lawyer uncles, right? But he always taught me to make the record. And so I would look at the statute and I would read the statute verbatim sometimes in some of my cases, and they looking at me like, oh, she don't know her stuff. No, I know my stuff enough to know that I have to know the law and have it correct for you to get anything in this case that you want to get, and for you to be able to appeal at any level. I'm not trying to impress anybody here. I'm trying to prevail and make you successful. And so all the language and the arms flying and the yelling and all of that, it is for the birds. I'm trying to tell you viewers, it's for the birds. Stop paying these people all this money for them to act, because we're not in TV. We're not on TV. It's not a television show. It's real life. And sometimes I think these shows do a disservice, right, to really understanding what it takes, especially in these types of cases, to be able to be successful. And so going into my next questions, and audience, please, if you have a question, put it on Facebook, put it on, we will get to you. Also, if you are on Zoom and you're joining us via Zoom, just put it in the chat and we'll ask our panelists to respond to your question. But this is a special gift that I get to y'all, because turn my live out with all of these questions and mad at me when I don't get to them. So I'm giving you guys an opportunity to get to your questions today. And so in that line of thinking, are there any pointers like you all can give? As Attorney Session was saying, we do some of everything, right? And we have different hats and we play different roles. Are there any pointers that you can give in trying to gain conservatorship or custody? And we use those terms interchangeably. In Texas, in the statute, it's conservatorship. When you're trying to be the primary conservator or the person who is able to have the child to reside with you and to make a lot of the decisions concerning the child. And the rights and duties can be shared and vary and things like that. And we can get into a little more about that. But as far as from your experience and in your practice, are there any pointers that you can give to the viewers about, you know, what it takes to gain conservatorship and how you do that? And I knew you were ready for this, Attorney Session. You were ready for this question because of all of the amicus work that you do. So listen up, because she's usually having to, you know, deal with that and make recommendations to the judge about who should have conservatorship. So look, I'm going to write it down too. I'm ready to hear. Go ahead, Attorney Session.
Okay. The best advice I can give is please don't lie on the other parent. Please don't lie to get some advantage that you think is an advantage regarding the possession of your child and access to your child. Please don't hold. You have to be able to really separate how that other party done you wrong, right? And their role as a parent for the child. It is so important that you really, really think about what you're doing when you make accusations about the other parent, that you know you are either blowing up, right? Mm-hmm. Or you are just outright not telling the truth, because that is harmful to your child. Most children, I would say most children, because there are some children, their parents really shouldn't parent, right? So I don't want to negate that. But most children, they have parents that love them and want to do for them and want a relationship with them. They might not have the best relationship with their children. They might not have the same parenting style that you have, but that is not to say that they cannot be a good parent for their child. It does not serve your child well to withhold your child from the other parent for no good reason, but because you're mad at the other parent, or because the other parent is not paying child support for your child. That's another issue altogether. The things that you want for your child to grow and blossom to their fullest potential, really think about that. And it's very hard. It's so many parents or grown-ups now that are in therapy because of messed up situations with not having a relationship with a parent. And it was because their other parent decided, I don't want you to have a relationship with your child for purely selfish reasons and nothing to do with the best interest of the child. So that's what I would say is don't lie on the other parent. And think about your child. I know it's hard to think about your child when you're hurting and you're upset and this other person done you wrong with another person or whatever the grown-up issues that are going on. And don't discuss the grown-up issues with the child either while I'm at it. Don't discuss the grown-up issues with the child. The child should not be telling the amicus, I don't want my daddy's new girlfriend to pick me up or to be around me. They shouldn't be telling the amicus that, right? Because they only got that from parents. Leave the grown-up issues to the grown-up and let's let the children, they only get to be kids for so long. Let's let them be children. So that's what I have to say.
I hope y'all were taking notes and writing this down, because she gave some good stuff. Go ahead, Attorney Bates.
So in terms of pointers, I would say, I guess if someone's coming in and they want to seek custody of their child, I mean, I'm gonna obviously look at the facts of the situation and probably ask about their role and their involvement in their child's life. For those people who are, I guess, actively seeking conservatorship or to be named as primary, I would say that the courts are gonna look to, well, have you been that parent that's been primarily responsible for the day-to-day activities of this child? What exactly have you done to show that you're the person who's been taking care of this child day in and day out? You know, what's the routine? Who's getting up in the morning with them? Who's feeding them? Who's clothing them? Who's helping them get to school or getting them to school? Who's the one that's meeting with the teachers, taking them to the doctor's appointments, making the doctor's appointments, taking them to the dentist appointments, taking them to their practices? Who's getting them involved? The main thing I would say is that you have to, like Attorney Sessions says, separate the adult issues from the child issues and keep that child as number one. You're going to have to put that child first and make that child be number one. And if you're actually seeking to be named primary, you know, look at what your role has been in this child's life. What the courts are going to look at, they're going to look to see who's been the primary caregiver of this child. And I think that's kind of what they look at when they're making decisions regarding who's going to be named as primary.
Absolutely. And there's a presumption that you guys will be, as parents, joint managing conservators, which
Correct.
means that you share in the rights and duties of raising the child and making decisions. Because, you know, we get those clients that come into the office, full custody. I want to be the sole managing conservator. If you can't get me that, then I don't want you. And I'm like, we have a burden to overcome. It's not that easy for you to just go in there and say, I want full custody, because we have a presumption, and that's a legal presumption, which means we have to overcome something to get you there. So do you have evidence regarding this, and that? Oh, and I just have to break it down to you. You're not gonna be the sole managing conservator, sir, ma'am. You're not going to be the sole managing conservator. That does not mean that I'm not good at what I do. That does not mean that I won't fight for you. It doesn't mean any of that. It means that I'm being truthful as possible, that as I can be, based on the law and the experience that I have in your type of cases. And I don't know how many of the same types of cases that we do all the time. So we know kind of the factual situations, you know, we're dealing with, the evidence that we're dealing with, what can get you there, what may bring you all the way, you know, to the door, but you can't cross over, you know, based on, you know, experience is a beautiful thing. If you have an attorney with experience, not saying that, you know, our newer attorneys are not very capable and able, but I and we who you have on this panel are able to give you advice based on our experience with other types of cases like yours. I know you think it's unique and it's personal to you, but we see hundreds of them all the time, and we deal with different judges, who have different ways of dealing with things. And so when you're paying for us and our advice, you're getting all of that, right? You're getting all of that experience and that expertise to be able to assist you in the best manner that we can.
Setting up realistic expectations.
Absolutely. And I'm so happy, Attorney Bates, that you pointed out those things about what have you done in the past to be able to get you to where you want to be today. And I just I just am direct. I try to, be polite about stuff and say it in the right way. This Southern hospitality, I'm still learning, but I am originally from Los Angeles, California, South Central LA. And so, y'all refining me. Your girl is getting better, but I have to tell you, brothers, and it's mostly the brothers, you come in and you want primary custody. You want to make now all the decisions about the child's medical. You want to make all the decisions about the child's education. You want to make all the decisions, about where the child goes to school and who they go to school with. And then we start talking about, 24 hours in a day and what happens and who does what and who's been doing what for the last 5, 10 years. And I asked you about a doctor, you don't know the doctor's name. I asked you about the teacher, you don't know the teacher name. I asked you when the last time you went to a teacher-parent conference, you don't have any of that. And it's not just brothers, I'm gonna say males, period, of all persuasions. We get mad or we get separated, and now you want the child and you are the better parent. You believe in your mind that you are the better parents. Males, I'm going to tell you, you have to come with something other than what's in your mind to believe that you're the better. To have evidence that you have been involved. You have actually been a parent and been involved. And I'm taking this time because I think it's important in answering some of these questions that we get all the time. The same type of questions that you all bring to us. Can you get me to be the primary parent? Can you get me sole managing conservators? And you walk out the door mad when attorneys who have integrity, ask you these questions because they're really trying to give you, as Attorney Bates said, realistic expectations. And so just to, put a point in that, because I want y'all to, really settle with that. When I say males, I'm not being sexist, I'm being real based on my experience. And this is what, we find and what we see. And for me to advocate for you, for Attorney Bates, for Attorney Sessions, for Attorney Curvey, for any attorney with a license in Texas who practice family law and know what the heck they're doing, then you have to give us something to go with. We can't invent facts, right? And so you have to come in with something that we can use. But I have a question from one of our Zoom viewers. They are asking if I've signed the child's birth certificate and later on find out through a DNA test that wasn't approved by the child support services that I'm not the father, what should I do? I knew we were going to get some of these questions. How many times have we heard this, attorneys? I'm telling you, that's why I have to dedicate this day and give a gift to the people. Let us get at it. Go ahead, ladies.
Okay, so those are my absolute favorite cases. It's generally called mistaken paternity. You have 2 years from the date that you know or should have known that this child may or may not be yours. So if you go out and you take an unauthorized DNA test and you learn that this child is not yours, that's when your clock begins. And you have 2 years from that date to file a mistaken paternity case and ask the court to do a legal DNA testing. And it's okay to pay for 2 DNA tests. You're getting ready to get out of this situation. And that's where you go in and you ask them to determine whether or not you are indeed the parent, even if you sign the birth certificate. Now, the law went really far in saying that you can be taken off as the dad of this child, and the child support can be terminated. But it did not go as far as to say that any money that you have paid into the system that you get back, because that's like, trying to get blood from a turnip. That girl doesn't spend that money.
You'd have to file a
Okay.
civil case to get that. If you want to go back and try to get that back from mom, you'd have to file a civil case. There's nothing in the family code that's going to allow that. And
Exactly.
that's just something that we couldn't get the AG's office, and really under federal law, we just couldn't get them to agree to do. So.
Right. Nicole worked directly on that.
Yeah.
In addition, if you owe child support, if you owe back support, you still owe it. The law went as far as to say they cannot hold you in contempt and place you in jail for it, but you still owe it. So you'll get off for, future child support, but you will not get off for past child support. And if you have developed a strong relationship with this child and you're able to show that you have developed a strong relationship with this child, then you can also continue to have possession and access of this child, even though you know that this child is no longer your biological child. So it's a beautiful law. It's a beautiful law. It just only went so far. So, I tell my clients, take the babies to the McDonald's. And that means take them to, tell mama you taking them to the McDonald's, and then go and run and get you a DNA test and find out what you need to know. As soon as that baby started looking like the milkman,
You already know something wrong.
you already know why your baby got red hair. I don't know. I don't know. But it's a beautiful law.
But to your point also, Attorney Curvey, if there's nothing wrong with a man asking for a DNA test prior to them signing any type of acknowledgement of paternity, or
Absolutely.
prior to them agreeing to be adjudicated as a father, you have every right to go and do a DNA test. And if you don't want to do a DNA test through the courts, you can always get one outside, but just know that that DNA test is not going to be admissible in court. And you're still going to have to go into court, ask the court to order a DNA test so that you can prove you're not the child's father. And at least that one would be admissible. And then you're on your way to getting that case resolved so that you're no longer having to pay child support for a child that's not yours. The other thing too is that signing a birth certificate does not make you the daddy at all. You would have to sign some type of acknowledgement of paternity to be and be an acknowledged father to be adjudicated as father. So whether you sign the birth certificate or not doesn't mean anything. Absolutely means nothing.
And can I piggyback something on that,
Yes,
since you said
please.
that? I have so many people that ask me, do I have to let this unadjudicated dad have possession and access, visitation, this, that, and the other? Then they break up, they get mad, and they're like, well, he said if I don't bring his baby over there. And I'm like, who said that was his baby? Well, he signed the birth certificate. I said, until a court says, y'all not married, okay, and he's not presumed, until a court says that he is the father, he does not have rights. He only has, you loaning your baby, mama's baby, papa's baby, I'm sorry. You were letting this person who has no legal relationship with your child, right? You were letting that person have access to your child. Absolutely. And whenever you decide to stop doing that, it's okay. If they feel like that's their child, then they need to hire an attorney, right? And go to court and have some sort of court order that says, this is your child and these are your rights and duties with your child. Until such time as that, they don't belong to that person. I don't care if they signed the birth certificate, they were there when the baby was born. Like I said, they can have a lot of presumptions, but they don't have any legal rights. I get calls about that all the time.
Or do you ever get calls where someone's telling you, oh, he's got so-and-so and he won't bring me my baby back? Well, do y'all have court orders in place?
Yes. I'm like, call the police, somebody kidnapped your child.
Right, exactly.
but they've been allowing him to play dad. So
Exactly.
this is when we get ourselves into the situation. And let me put this out there too. We are licensed family law attorneys in the state of Texas. And so all of the things that we're discussing is based on Texas law. And so if you are viewing this, because I know we thankfully have been shared and reposted everywhere, and really have gotten, this webinar series to be very popular on social media. So I wanted to put that out there. Every state has its own family law statute. And it may be different in your state and in your jurisdiction. And so we are family law attorneys that practice in the state of Texas and are licensed in Texas. So take that with, what you may, in terms of the advice that we're giving is definitely based off of Texas law. And so again, still, we are only giving guidance based off of our experience and expertise. We are not creating an attorney-client relationship with any of you who are posing questions to our panelists. And we definitely advise you to go seek a consultation from an attorney in your area. Any of these ladies will accept your calls for a consultation. You can retain their services if you have any pending family law matter, or you think that you are going to need them to be involved in some family law issue. And so I wanted to just say that because we are giving so much valuable information, ladies. I'm telling you, these people got a treat today, because how much y'all usually charge an hour? I know I'm probably the cheapest, right? What's your hourly rate?
300.
I'm 300.
I'm
Yeah.
250. So I'm probably
Okay.
the cheapest.
I'm 250 too. And
I know I need to raise it. I haven't.
I know, because everybody be so upset at me, all our, colleagues who have been doing this for years, like, girl, that it's about time to raise your rate. But I just actually switched over to 250. I have not been doing that a long time, but it was based off the encouragement of other attorneys who, like you do good work, you know what you're doing. You need to charge for your experience and for your expertise, because like I said, you get all of this when you hire an attorney who has, some history and experience in working cases that are definitely similar to some of the things that you are experiencing. So we kind of have the blueprint in the way to handle and operate in the system that we've gone to work in. So just wanted to put that out there, so we're clear with our viewers, our responses and where they're coming from. And if you have any questions, again, this is your opportunity. This is my gift to you. Me and Brother Theo, we turning up in October, so we letting y'all get some of that, birthday love. So it is definitely an opportunity, because you heard these ladies' fees. So ask your questions. If you have questions, you can put them in on a Facebook, if you're joining us on Facebook Live, or you can put them in the chat in Zoom. Thank you for your question, viewer. Hopefully that helped you. And so,
and
ladies,
Sister Qiana,
go ahead.
There's a follow-up to this that I just wanted, to know, I guess, because I'm looking at the Zoom that a viewer says, and this was done in California. And so what happens in the situation if this situation, let's say a person, the child is born in California or whatever state for that matter, the father, let's say, moves, to Texas, and that situation comes up, signing the birth certificate or doing whatever, and finding out later on that he is not the father, but now is domiciled, that father now is domiciled here in Texas, but the child still lives in California, even vice versa. How does that affect it jurisdictionally? What law would prevail, if you will?
California. Child lives in California.
Okay, so it's where the child resides then. I
Jurisdiction
see.
is proper in California. That's what they'll have.
Okay. Okay.
And so, yes, that's why I wanted to, put that caveat in about, the things that we're talking about and based on our experience as practitioners in Texas. I cannot give any information about what California would do, how they would handle it, because I do not know. And I do not practice in California. Even though I'm from California, it is very similar to how we view things in Texas. But I have a license here, and y'all not about to mess up my license. So I'm going to stick with what I know as far as being a licensed attorney in Texas. And so we're going to continue on with the conversation, ladies. And we have Ms. Curvey, who has shown us her beautiful face at this point, and she's joined us, but you've heard her, and she's giving you guys some jewels, some nuggets, okay, to jot down on some paper. So I really hope you guys are taking notes, okay? And in terms of you guys' experience, lady, because we have, let me ask you, what are the majority of the cases that you see that come into your practice?
In mine?
Mm-hmm.
So most of my cases are client case, of course they're client cases. Most of my cases are custody cases with men asking for custody of their children. And so I do a whole lot of, have you been taking care of this kid? What have you done? I always ask them to keep copious notes. The first thing they have to do is they have to purchase a calendar, and I want them to write it in their handwriting. I tried to pick up the child here. I tried to pick up the child there. I went to PTO meeting. I did this, I did that. I get them to be super involved with these children before I file anything, because there's nothing I can do for you if you are not involved with this child. I just can't do it. My magic wand is broken. So if they are not involved, there's really just not a whole lot I can do. But that is the majority of my cases. 90% of my cases are dads asking for their kids.
Attorney Bay?
So my caseload it runs the gamut. It's divorce, it's child support, it's enforcement, it's custody. I mean, I pretty much run the gamut with different family law cases. But one thing I did want to also add, just to piggyback on our last issue, is that there's been this misconception, I think, a lot with guys who somehow think that, there's just no way I'm going to get custody, and moms always win and they always get custody. And I would say, and I'm pretty sure all of us will say, that is not the case. Not now, not in Texas, not in Harris County, not in any of the surrounding counties. Dads are getting custody left and right. It just depends on who is actually involved in this child's life and who's been primary caregiver. And if you fit that role, then yes, you can definitely get custody. But then there are also those times where, something's happened. Maybe there has been some issues with mom. I don't know, maybe with drugs, per se. That is also one way that, guys are potentially going to get custody. But I do want to put out there that there's no longer should the conception be that moms always get custody or they're automatically going to get custody, because that's just not true at all. Guys get custody all the time too.
Agreed.
Go ahead, Attorney Session.
As Brother Muhammad said in the beginning, I have kind of honed my practice. So now I really only do amicus cases, and I mediate family cases. And amicus cases, for those who don't know, is when the judge appoints me or the parties agree, and then the judge would sign an order saying that I can assist the court in determining what is in the best interest of the child or children.
And she's a great amicus in Brazoria County.
Thank you.
She is our go-to.
And I do represent parties and children in CPS cases, but I don't do any more representing of parties, but I do represent children. And like Attorney Bates said, primarily in Brazoria County is where I do most of my amicus work.
And I would say for me, I believe I'm like Attorney Bates. I have everything that comes into my office, really. So I can't even really say what I do more, like more divorces are suit affecting parent-child relationships. We usually say SAPSARs. I think the least amount I do is the child support stuff is just in terms of the 4D side of it. But of course, child support is always involved in suit affecting parent-child relationships. It's always involved in divorces, if there are children involved, of course. And it's always involved a lot of times in our enforcements because people want to get their money. And you know, that there. But in terms of people just walking into the office for 4D cases, I think that's my least amount of cases that I do. And I also have a lot of women that I work with who retain my services, but I do a good group of males as well. And that's why I wanted to put that out there, you know, for the males to, you know, kind of help us help you. And I'm glad you did say that, Attorney Bates, that there has been a shift. There really has. Now, I would say when I first began practicing a while ago, you know, I've been doing this 16 years. So I would say at the beginning, you would go in and I was like, you have to be Jesus pretty much to get custody of this child, because it was just so sexist. It really was. We had to show so much of why, you know, the male should have it. Yes, in some courts.
Yes, absolutely.
Yeah, and that there has been a shift within the couple of years that I've been practicing, that the judges and the law really is advantageous to the best parent.
Yes.
Who's able to show, you know, that they can better parent the child or be there for the child and have been there for the child. So there is a shift, males that's on your side. So you do need to come in, you know, with some evidence and some information that we can use. And, you know, of course, we have various issues that make, you know, one, you know, upstand the other one or what have you. But it's all about evidence and information and background and all of that to help us with these conservatorship cases. Go ahead, Attorney Bates.
I mean, I was going to say, and I can tell your audience that there's going to start being a shift with how we do child support too. And it's one of those things that's always come up every session that we've kind of, you know, been able to kind of set aside, but it's coming. And there are several states that look at both parties' income prior to determining what the child support should be. And I honestly see that happening with Texas, because more and more bills are getting passed to address this child support and making it kind of across the board so that you're looking at both parties' incomes. And I can see that probably happening this upcoming session.
And I also wanted to add that not about the child support, but I know in enforcement cases, in a lot of enforcement cases where moms are not letting the dads see their children, sometimes the punishment for that is not only contempt by going to jail, but it is taking the children from the possession of the mom and placing them in the possession of the dad. So that's another thing to be mindful of as well.
That a lot.
It's happened a lot of cases where I've had dads that have gotten custody. Those cases were more so because mom was like really not taking care of children or on drugs or with child predators in the home or something big like that. But a lot of cases since then were cases where mom was refusing to allow the children to go with dad in their times of possession. Hiding the children, saying the children not available, not letting them talk on the phone, just all kinds of things like that. That can turn into dad having custody of the kid.
Absolutely.
Primary custody.
And one thing that I do with the cases that I have with the dads, I always focus, and I'm sorry, y'all, I look a hot mess, but it's just been a long week. I focus on parental alienation, because if they are, hiding and secreting the children and things of that nature, based upon the things that they do and the things that my clients write down in their calendar, when we go into court and we start testifying as to that, it shows that mother, in this instance, that mother is not a person who can co-parent. And if it shows that dad has better, for lack of a better word, better sense, and he knows how to co-parent better, then that's generally how my clients win custody. I've gotten 1-year-old little girls for dads. I've gotten a set of twins and an extra for dad. That's pretty much all that I do. I'm sorry, y'all. I'm sorry, my cat is
trying to be in our program. Look, they're gonna have you as a Mimi like they had that other attorney that was on with couldn't remove the cat thing from his thing to Qiana as a cat. But yes. You definitely are giving some great points as far as that is concerned. And we're gonna transition to the child support, because I think this legislative session has changed some stuff already. But I want to kind of stay on this point as far as when we have a conservatorship battle or custody battle, or however you want to say it. Most of those are we find in divorces when, of course, people and families are separated. And we also have it in suit affecting parent-child relationships. And these are cases where there is a child involved, but there's no marriage. So there is a child involved, but the parties, the parents, have never been married. And they're seeking to have a conservatorship orders put in place, and also visitation and child support when they're entering into the judicial system. And so in that battle, it can get a little heated. It can get very emotional as far as, trying to push your position in the way that you should go. And you gave some great points, Attorney Session, when you were saying as an amicus too, what it is that you look for. And so I wanted to let the audience know this is the same stuff that we're talking about in terms of behaviors and information that you would need as far as evidence going forward, male or female, if that is what you're trying to do in terms of obtaining primary conservatorship or custody. And want to tell you some of the things not to do, which Attorney Session had great points. Don't lie. And I think another major point I want you all to take away is don't alienate, don't use the children as a tool or a pawn, or something where I think we experience a lot that each side is kind of using the child that they think to their advantage to gain custody by being nasty in some regards to the other parent. So just want to present some other not to do things in these types of cases, and then we can transition over to our child support discussion, because we are at over halfway, and you guys have gotten a lot of information, but I'm telling you, keep your pen in your hand, because this child support part is definitely something you want more information about. But let's go into what are some things you just don't want to do in terms of gaining custody or conservatorship if you're dealing with a suit affecting parent-child relationship, or if you're dealing in a divorce situation.
I would say stay off of social media, first of all. If you're trying to go and get custody, stay off social media. And and I tell my clients is, do not text anything that's derogatory or obscene to the, to the mother or the father of your child. Keep it all copacetic, and always put that child first, because what the courts are looking at and what they primarily are going to focus on is what's in the best interest of the child. And so those are probably the two main things I say, or I tell them is stay off social media, don't be posting anything crazy. And by all means, do not put anything in writing via text or email to the other parent that you know is derogatory, obscene, or is going to piss them off. And the other thing is this: if you're on any type of Our Family Wizard or any type of talking parent app, again, same rules apply. Do not post anything derogatory or negative or obscene or anything like that directed towards that parent. Those are one of the main things I would say don't do.
Major.
One thing that I tell my clients is, don't bring new booty to meet old booty. When you don't need to bring your new girlfriend to pick up your kids.
Absolutely.
When you are picking up your children for the weekend, that is your time to be with them, not for girlfriend to get acclimated to your children. That is y'all's time, and you need to keep it as that. Because if you ever want to see a woman mad, and you ever want to see somebody go after you with full force and vengeance, then bring that new girlfriend with the flat stomach and the big bottom over there, and she done had 3 or 4 kids from you, and she don't look like that no more. Don't do that. It's bad news all the time. It's bad news all the time, and it's not bitter. It is simply you're being disrespectful. I also tell them, do not put your girlfriend in the middle of your communication with the mother. If you don't have enough sense to know how to text this person back without your new girlfriend or your new boyfriend having to put their 2 cents in, then you don't need custody, and you might not even need possession and access. Keep that situation just between the people who were there at conception of these children. If new girlfriend wasn't there at conception, she don't need to be there at visitation. And that's the way that I tell them exactly like that. I don't have much of a filter. So if they can't understand it in common English terms, they probably don't need to be a conservator.
Absolutely. You guys gave some great points, especially in this time that we're in, this social media. We had to learn new rules based on introducing evidence of post and, being able to lay the foundation, and these are legal terms, about getting in somebody's Instagram and Facebook postings and pages, because it's so evolving in the time that we're in. But they're major in these types of cases, and they are very impactful, and they are really sometimes what make or break the cases that we see sometimes in terms of the possession and access, whether you should have visitation. If it's your weekend and you're posting, and you're puffing and you got, different things on your site, that could be very damaging. If you're in a custody battle, just know that the other side is constantly checking. And so if the child is with you, and you're posting some things on Instagram that may be considered inappropriate, even though you don't feel like it, it may be considered or construed to be inappropriate, and those things are able to be captured and downloaded and presented as evidence, then you may find yourself defending something that you really didn't have to, because you didn't have to post it. You didn't have to upload it. And so always be mindful that you are in litigation. And if you're not in litigation, if you're heading towards that, you want to start cleaning up your social media accounts. Mm-hmm. You want to make sure that you are presenting yourself in the best light possible. because I could say from my experience, I think that this is a more traditional type justice or judicial system where they don't like all that foolishness and craziness. You know, we come in with and think we can live our lives and just do whatever we want to do. And so if you're going into something and you're knowing that, not that you can't be yourself, not that you can't, you know, be an adult and have a girlfriend. You cannot have a girlfriend and present a girlfriend when you're going through a divorce. Let me be clear about that. You cannot. You know, nobody, you grown, you can't nobody, you know, like.
Because you're still married. You're married till you're not.
Married people don't have girlfriends.
And that's what I've been holding. That's what I've been wanting to just jump in and say that.
Yeah.
Please, please. I don't want you having, as the amicus, okay? If this is a divorce situation, okay? Please don't have not only girlfriends, I see fiancés, I see people that move in with mom or dad. I see people that come to court with mom or dad for their divorce proceedings. I see, you know, other baby mamas, other baby daddies trying to tell you what you should be doing in this particular case based on their case and who you should be paying child support. They so busy looking out, making sure they getting their child support. They don't want you to pay child support for this other. It's so, the best thing to do is let the parties, the people who are actually parties, handle this situation and leave all that advice from your new other, ex-other, leave that where it is in the rear view, okay? Or the side view, technically, side view. Don't let that get involved in what's going on with you right now. Because that, especially if you're in a conservative, I mean, it's traditional, yes, but in Brazoria County, where I primarily practice, it is very conservative, very. And I guarantee you that I don't care if that is mom and her new boyfriend, mom and her new girlfriend, dad and his new boyfriend, dad and his new girlfriend. Y'all might be living together, but I promise you, when the children are with you, that other person can't even spend a night at their house, right? So they're gonna have to go to a hotel, get another place to live. I don't know what they're gonna do, but they can't be in that. If you want to have a relationship with your children and see your children, they can't be there.
That's right.
So it's best to just take care of what you have to take care of. While and leave that. And it's time for that. It'll be time for that later.
Right. And just because you separated doesn't mean you can still do all that. You cannot.
Like somebody asked about California. Okay, this is not California. We don't have legal separation.
That's right.
Okay,
that's
you're
right.
either married
or you're not.
Or you're not. And when you're married, you're married.
And filing a petition for divorce does not mean that you're not married.
Absolutely not. You are still married.
Even if you haven't lived together for 3 years,
you
5
still
years. And all those children that you're having that are not with your husband on record, they belong to your husband until a judge says they don't.
Absolutely. He is a legal father.
Take care of your business the right way.
Do one thing at a time. One thing at a time.
And just a web that we start weaving when we involve so many people, and to understand the impact of that, because it is, you know, the law that you're married until you're divorced here. And so bringing in other people and involving them in the activities of the litigation and different things, you're giving the other side an opportunity to have more to use against you, and also to have witnesses and different parties come and be brought forward to participate in something that you might not want them to participate in because their character, their background may affect you in your ability to have possession or primary conservatorship of your child So just be careful. And sometimes you get upset when an attorney tell you, some of these things not to do, as if we're, making you to appear as a child, or, chiding you or anything like that. And it's not that. We just know what it takes to be able to be successful.
Right.
And especially, like she was saying, in some counties and some jurisdiction, it takes even more in terms of walking that straight line, because you know who it is that you're dealing with. And we, know the judges and their likes and dislikes, and, some of the things that they take more serious than others.
Right.
And it's not a game. We don't think that this is a game when you're going through something with you and your family, but you have to know the environment, right? And strategically prepare your case in the court that it's in. And so what it takes to do that, your attorney should be trying to guide you through that, and help you to maneuver in that way. And so thank you, ladies. That was a whole lot of truth telling that needed to be told. And so we are glad that we were able to give those don'ts, to the audience. So we have more successful outcomes, when it is that we're going for conservatorship or custody, however you want to say it, in these courts and dealing with some of these situations. So we're going to transition on. We're down to, almost 30 minutes of the program, but I do want to get in this question, because child support is super important, because everybody needs money. It's real. It's a reality. Some people have to pay it. Some people receive it. We on both sides. Sometimes we're trying to get it, and sometimes we're trying to, modify it, or, deal with it in terms of how to best move forward in the best way, really, on whichever side we're moving forward on to represent the party and their financial interests, because that's what it is about. And so we have a questions from the audience. What advice would you give if a parent's financial position has changed since he or she was ordered to pay child support, be it changed for the better or the worse?
It depends. I mean, has it changed for the better? Because if it's changed for the better, then the advice would be to seek a modification and ask for an increase.
Unless you represent a person that it changed for the better.
Depends on who you represent.
Yeah, exactly. Now, if you
You
represent
keep your mouth shut and get off of social media.
I'm gonna say, and stay off social media.
Good. Yeah.
Thank you. Yes. Don't be posting on there that you just bought a new house. Like, that's what you don't do.
With your new boo.
Right.
With your new boo.
And back in the day when we were going to court, I'll tell it depends on what we're doing. If I'm trying to keep your child support down, I'm gonna say, okay, you can leave them Gucci's at home. Take that watch off. I need you to get your little plastic watch and put it on. Matter of fact, if you work for, wherever you work, depending upon what your job is, I may tell you to come in with your uniform. Just depends on what we're working on. Just depends on what we're trying to do.
So it really goes to the person you're representing. With this question, because it's of course for us to advocate your position, right? If we're representing you. And so if you are aware, let's say, and I'm going to use these terms, okay? If you are the obligor, that means you are the person that pays child support. And if you are the obligee, you are the person that receives child support. So if you are the obligor and your finances have increased, then most likely the person you're paying, the obligee, is going to want to get a little extra money, right? And so if that's the case, they will bring that to the attention of the court by filing for child support if they are aware that you are working now you're making money, so they want to now start getting child support on record. Maybe you were paying before and you guys had this system that, you give what you could give and all of that, but then they see you're flourishing and you're doing good and you got this new job and they're like, no, I want it on record. I want it through the, child support office, and I wanted to get it through the state disbursement unit, and I want my child support to come on time every time. And so they may file, to get child support, and it will be based on your income, what it is that you're receiving. And if you are the obligor and you already have a child support order in place, then that may be, something that you will have to deal with. If there's knowledge by the person that you're paying, the obligee, that you're making more money, that they want a modification to get some of that money. If you are the obligor and you're making less money, or you don't feel that you have the ability to provide as much as the other person is requesting, then of course it will be based off of your income, what it is that you are making. But it is also a way for you to request a modification, because, I was here at one point, Judge, and you got me paying $1,500. I can barely keep my head above water. And so you would want to ask for a modification, and that means a change. That's all, a change in your child support amount to lower it or decrease it. And so you would file a petition to modify in that regards, which I think, this new legislative session has really made that more doable in terms of coming in. You always could do it, but I think it was very hard for a lot of the obligors to come in and feel like they had an opportunity really to get that child support amount decreased. And I think the new 2021 legislation that became effective September 1 has really, kind of changed the game with, getting a decrease, or modification because of, somebody's incarceration, or getting a modification, based off of actually what, you're paying for other children and all of that. And so I think this is a great opportunity if you are the obligor who wants a decrease to try to push that on through, and also to, see, how that can, the new laws that are now on the books can, benefit you. But what I do see happening, and I don't know if you all see the same, we have obligors who have, a child support amount that has been set, maybe, when they were doing well, when they were, at the top of their game, and they've had so many life changes, from that point, and they're working on a child support order that was put in place in 2010, and here we are in 2021, and they're paying that same amount, struggling to pay that same amount, when there's been so many turns and ups and downs and different things, and have never gone forward to modify, but are complaining and are struggling to keep up with the amount, and sometimes finding themselves in arrears, which means amount that they were supposed to pay that they didn't pay is just adding up. It's just, building up because they have not gone to get that change. Do you all see that a lot?
Yeah, I see that a lot.
Absolutely. And I'd like to say this too. If child support orders, not ones coming out of divorces, but just general SAPSers, are there because people weren't doing, obligors were not doing what they could be doing without a court order, right? If you know the right thing to do, which is to provide for your child, which let me back up first, because I'm gonna speak to the men out there as if they were my son. I don't care if you were her first, and if you believe that she has never been with anybody else. To me, my advice always is to get a DNA. Get you a DNA when that baby is born. I understand that you believe with every fiber in your being that that's your child. And that's good. Okay, well, let's just confirm it. Confirm it for me. Confirm it for me. If not for yourself, for me. Confirm it. Okay. And then take care of your child, right? I know men that take care of their kids and take care of their kids well, but mom decides she wants the child support order, even though they're consistent. They're doing, they paying for daycare. They paying for, you say baby needs this, that, and the other. They doing all of that, but they're convinced they need a child support order. Get you one, but just understand, moms, that you may end up with less
Absolutely.
than what he was doing in the first place.
Absolutely.
It goes both ways with a child support order. It goes both ways. Yes, a lot of people do need them because unfortunately, there are men out there that are not doing what they're supposed to be doing. But on the other hand, don't drag somebody in court, right, and make them miss work when they're taking care of their child and doing what they're supposed to do for their child, right?
Now, to that, I also will say this. I mean, and this is kind of what I tell clients as well. If you're going to do for your child and you don't have a child support order, kind of keep track of what you're doing. Keep track of the financial financial money that you're giving to them, and don't do cash. Try to do a money order, a check, or a Cash App, Zelle, something that keeps track of everything that you're giving her. Because at some point, if there is no court order, always know that she can always come back and ask you for back child support, even for the time that you've been actually supporting this child. And you'll be forced with having to try to prove up everything that you've done. If you have a record and accounting of everything that you've given her, then it's not a problem. Ask for it.
Now, I do something a little different. I suggest to my clients from the beginning, put yourself on child support, because in Houston, we have hurricanes, we have all types of floods. You can lose those papers. Now, just like Nicole said, do it through Zelle, do it through Cash App, but those are new mechanisms. And so, back in the day, I would tell them, put yourself on child support. That way you don't end up having to pay back Medicaid, even though you were providing health insurance for those children, or that you end up paying back for SNAP benefits, even though you were providing for them. It makes sense. And when you get a new boo and she starts saying, I'm not going to let you see my baby, that child support order also has conservatorship in it. And so you will have a right to see your child. It will not be, it's going to take me 6 months to take her to court so that I can get rights to my child. No. When that baby is born, I ask gentlemen, and I know they're like, I don't need the man to tell me how to take care of my kid. Yeah, but you do need the man to put something in place so that you can exercise your rights.
Right.
You won't have to deal with back support. You won't have to deal with her playing keep away with the baby. You can actually have a paper in hand that not only shows that you are DNA the father, it shows that you have conservatorship, that you have joint conservatorship, that you have possession and access rights, that this baby does not need SNAP benefits because you're taking care of it, and this baby doesn't need Medicaid because you are providing health insurance for the child. It makes everything neat. And I know people don't like to be on paper, but it's probably the best paper that you can be on.
Absolutely. And they need, and people need to get off of that. You need to get off of saying, oh, well, I don't want them people in my life. No, sometimes you do need them people in your life so they can keep track of everything you've done so that no one else is coming back after you for something that you've already done. So it's having them people in your life is not always a bad thing.
And I wanted to say this.
And one more other thing, Qiana, before
Go ahead.
I lose this thought. To the ladies, if a guy wants a DNA test, let him get the DNA test. It doesn't mean that he doubts that the child is his or anything. It may not mean that. It just, for a lot of times, they're getting the DNA test because it's something that they need to do, and it's required for them to do in order for this child to be adjudicated as their daughter or son, whatever the case may be. But it doesn't necessarily, they shouldn't be offended by someone asking to have a DNA test. It doesn't mean that they're trying to say anything negative about you. They're just protecting their rights. That's all.
Right. And it's a legal way to get into having conservatorship or access, because I can't go in there asking for conservatorship or visitation to somebody else's child. I have to be able to prove that this is my biological child, that I have a connection with this child. And so don't, take it personal as far as that is concerned and, start being all ugly, because it's unnecessary. Sometimes we have to, use that vehicle to get where we need to go and have orders in place, for the stability of everybody across the board. But I also wanted to say this, that the Office of the Attorney General works for the state of Texas. I think sometimes we get a little confused, and I was real, tough on the brothers earlier, our males, but ladies, I think we get it confused sometimes. They are not your personal attorneys.
No,
The
they
Office of Attorney General, who do most of the child support cases, when we say that, those are usually termed the 4D courts. When you go in and you may have a child support conference and you're meeting and you're talking to a child support officer who are not necessarily attorneys, right? They're just sitting in there trying to, compute some numbers and see who owes what and, go from there. And then when your case is in court and you are actually with an attorney that works for the child support office, that attorney does not represent either party.
Nope.
And so just to be clear on that, that attorney does not represent any parties. And I want to get on the ladies a little bit, because I have to be fair in my truth telling. You have to pay child support too. Sometimes we think that because I'm mom or I'm a female or something, that doesn't apply to us. Oh, he can have the child, but I'm not giving him any money. No, ma'am. It don't work that way, right? Because you have to provide for the well-being of the child as well. And so don't think too much of yourself in that regard when you're going into a litigation to believe that you will not be ordered to pay child support, ladies, because you will be. And your attorney can't do nothing about, you being a female and you being cute and you thinking that, because you mom, that you shouldn't have to pay him like he paid you. It don't work like that.
That's right.
It definitely does not work like that.
The other thing I would say to ladies is, if you know that guy has taken care of this baby and that he has given you money, just because they offer you and they say to you, would you like retroactive child support? Don't be greedy, be fair. Don't do that, because what you will set up is a resentment for the next 18 to 25 years. And because that person has been, under, 10,000, they started at $10,000, but by the time they finished adding all the interest, they paid you an extra $20,000. $20,000 is not worth having the father of your child hate you forever because you lied on him. Don't do that to them. It's not fair and it's not right.
Also be mindful that it's not just parents that can go to the Attorney General for child support. It could be your mother, the grandparents that have been keeping and raising your kids while mom or dad has not been contributing anything to the lives of the children. If the support of the lives of the children, they can go, and parents can pay a grandparent, a non-parent, child support as well. So It's not just parents that can seek it, it's grandparents or whoever the children have been living with and someone has been supporting those children.
Absolutely. And I'm glad that you did mention that, Attorney Session, because we see that a lot, especially in our community that we have, of course, because we have a village, right? And we have, sometimes aunties and grandparents and different people raising the child, but we have an old child support order where the mom initially went in there and got a child support order and continues to receive the money. And sometimes,
and don't have a kid.
Yeah, and sometimes they give it over to the relative who has it, and sometimes they don't. But what I wanted to just say with that part is, however we are going to handle that and raise our babies, let's raise our babies. Whoever have the best way to do it, let them do it. But you can go in to get it modified so the person who is in actual possession of the child can receive that money. And sometimes we call it redirected, and sometimes you can just go get a straight up modification where the order will say that the money is to be paid to, and it'll be grandma or aunt or whoever, uncle who has the child, instead of listing and continuing to list the person who is not in possession of the child. So you can do that through the Attorney General's office. You can do that by retaining any attorney, that practice in this area to make sure that, the paperwork is complete and it's right. Because sometimes we do a lot of things, just because that's how we've been doing it. And it's not necessary. You can actually have correct legal paperwork to say who gets what, and how it should be distributed. And it just helps everyone across the board, right? To make sure that everything that is in place is in an order as it should be, because it's easy to do. It doesn't take a whole lot to be able to do that. If you want the records to reflect what's actually happening and what's going on in the family. So I just wanted to put that out there. And so we are going down to our last couple of minutes, and it has been such a party with y'all. I'm so happy that y'all joined me today, ladies, because sometimes, even though I know y'all out there, because with COVID, sometimes we be, in an island on our own, because we don't really get to see each other that much as we were downtown. So I'm like, we are family. I got all my sisters with me. Hey. And so I'm so happy that you guys joined me today. And do we have any other questions from our viewers, either on Facebook or on Zoom, Brother Theo?
Yes, ma'am. We had one question that I had gotten dealing with arrears, and I just want y'all to answer this. Suppose somebody is in arrears with child support. I know the answer to this, I guess, but just from y'all's standpoint, then they get a modification, and their modification, let's say, reduces their child support order. What happens then to the arrears? Is that sort of adjusted at all? Does it go away? Because people have actually, one person actually already texted me that, and I said, well, let me ask the panel, because I'm, don't really know, I would imagine, but hey, I'm gonna leave it to the professionals to answer that question.
Okay, I'll go. So those arrears are generally they're confirmed arrears, and they're reduced to a judgment, and you typically will get a payout on those arrears. You're not going to get the whole amount that's owed. You're going to have a payout that you're going to get monthly that'll be taxed onto whatever your new child support amount is, plus the health and dental insurance as well.
And so if you owe that money, you're going to continue to owe that money.
You owe it.
You owe it.
You will continue to owe that money unless the obligee decides to waive.
That's true. They can do that.
Arrears.
Right to do that.
That can definitely happen. And that I've seen it happen on some of my cases where, somebody, was able to get that, done.
Well, and
based
that's
off of the best interest of the child.
But that's also too where you and let's say mom and dad have a good relationship or a good working relationship with each other. If y'all go in and you're cool, and hey, maybe she knows you've been struggling, having a hard time, she can waive whatever is owed to her, whatever money is owed to her. Now, she can't waive any money that's owed to the state, but any money that's owed to her, she certainly can forgive an amount of that money that's owed to her. She can forgive it all if she really wants to. It just depends on, I think, sometimes what your relationship is with mom. And if you all have a good working relationship and she's, willing to do it, yeah, you can have that done. Otherwise, you owe it.
And I want to say this too, and I'm glad that you made that point, because sometimes we do have a good relationship and working relationship with each other, and then the Attorney General gets involved, and the Attorney General is nasty and got people acting nasty, against each other. And, kind of don't allow that. That's why I said they work for the state of Texas. And I'm not, of course, disparaging all attorney generals, and not at all. We work with everyone across the board. We have great colleagues, but there are those, who come in and are really pitting parties against each other unnecessarily. And sometimes your parent on the other side is required to file child support because they're receiving Medicaid or some benefit from the government, SNAP benefits or something like that, where they may like, yeah, we cool and you give me money and we got this relationship going on, but they're required to get some of these benefits. They're required to file a case with the Attorney General's office. And so that's why they do so, and they show up and they have to be there to continue to get the benefits that, of course, that they need. They're helping them in some kind of way in their families. It's not a personal attack against you, what you're doing or not doing, or your relationship or anything like that. But medical coverage is very expensive. For health insurance, baby, as far as you being able to cover that for yourselves, I can tell you personally, it's a struggle. It is a real struggle. And so if, they're required to do that, you guys kind of work with each other the best way that you can. If you have to go to the Attorney General's office and be very mindful, of who they work for and why it is that you cannot waive. Like, sometimes you're like, oh, I don't owe $10,000. And why are you saying I owe $10,000? And they're not saying you owe $10,000. They're saying that we provided these medical services for your child and you owe us, right? And so mom or dad is not going to receive any of that money. They're not going to get any of that. That doesn't go into their pocket. That goes back to the state of Texas, who's providing, either health care or some type of benefit, to assist the family. So just, I think knowledge helps kind of sometimes with keeping some of the emotional stuff down and feeling the attack, if you are finding yourself in a situation dealing with child support with the Office of Attorney General. And I also want to say in those conferences, in those meetings that you have, they are typically not attorneys. And so you do not have to sign anything. You do not have to agree to anything. You can be represented by an attorney at those meetings, right?
And you can get your own attorney. Just keep in mind, the AG's office, they do not represent either the dad or the mother. Absolutely. Get your own attorney so you can have someone actually give you legal advice, because when you go in there, they don't have an obligation to give you legal advice. And so you do really need to have your own representative in all of those meetings. And even when you go into a Title IV court, get your own lawyer.
And while we're still, go ahead, Attorney.
And I wanted to say this too. Be mindful when your child graduates, the state is not necessarily keeping up to the fact that your child has turned 18 and graduated. Right. So you have to get that stopped. That's not usually stopped automatically, right? It's no slip. They're not keeping up with all of these kids and when they graduate. So you have to stay on some things. You have to stay on top of. You have to make sure that the child support is stopped. It's people that pay child support for kids that are in college just because they think,
why am I still paying? They're trying to figure it out.
Right.
That child grown.
Right.
But and also I wanted to say this, because in Texas anyway, you can be obligated to continue to pay child support after your child is 18 if your child is continued to go to high school. They haven't graduated yet. And so it's hard for the state of Texas to know what's going on, or anybody to know outside of you all's relationship what's happening with your child. And so if that is your situation, then you may be obligated to continue to pay. However, if that's not your situation, then you need to notify, you know, everyone involved, the obligee, if it's coming through the Child Disbursement Unit, the Office of Attorney General, the courts, that this child is 18, they've graduated from high school, so your child support obligation will cease and you will no longer have to pay. And in these last couple of years, we also have had the requirement to pay dental as well. And so that was something that was added on to the obligor's responsibility. And because the obligor is a person who pays child support, they are typically the person also responsible to have medical and dental insurance, right? And so if you do not have the medical and dental insurance covered through your employer or through a way that you can handle it, and the obligee has those things in place for the child, then you will have to reimburse the obligee for those things. And so hopefully this has been helpful. I learned a lot, ladies, as well. Go
Can I
ahead.
say one more thing? And also understand that if you have a disabled child, you may be required to
Yes.
continue paying child support to support your disabled child, because your disabled child, even though they may become an adult, they may not be able to care for themselves and support themselves. I just wanted to
Absolutely.
make sure. I added.
Absolutely. Absolutely.
Yes, beyond 18.
Mhm.
Yes, absolutely. So, I mean, all this great information that y'all have got today, I'm trying to tell you, I hope y'all had pens in hand, typing on your laptop, on your whatever, because this was such wonderful information that you all have received today. And I know that it covered a bunch of people with a bunch of problems and issues in the family law arena, because these are some of the common questions that we get all the time. So ladies, I thank you so much for taking on this topic today and for joining us today. And I cannot leave without allowing Attorney Session, because we've given so much on this program, I'm telling you. And we haven't asked for anything but you all to take this information and to share and to repost. But it's such a beautiful opportunity when you give, to give in return. And so we are asking for you all to support this beautiful, beautiful project and cause that she has going on. And so Attorney Session, if you can provide our viewers more information on how to support, because I'm telling you, I have some of the best viewers out there. And they've been taking this ride with me, and I want them to help me to help you on this project that you have going on. And I want it to just light up for my birthday. This is my birthday month. So y'all cash app, y'all do whatever y'all want to. We got to represent. Go ahead, Attorney Session.
Thank you. Absolutely. I appreciate everyone for your participation at this webinar. I know you all have learned a whole lot. And I did touch on the fact that I have represented parents and children in CPS cases, and I've done that for over 20 years. And a lot of the problems that occur when children come into care is unfortunately due to substance abuse in the home. And not only does that have a devastating effect on the children in the home, but the children also are traumatized when they're separated from their parents. That even if they go to a family member, they go into foster care, it's traumatizing for children. So with all of that in mind, I have founded a nonprofit. It's a residential treatment center for women and who are mothers and their preschool age children. And it's called the Success House, A Road to Recovery Incorporated. And for short, Success House. And Success House is so that mothers can get the tools they need to not only obtain sobriety, but to be successful in life. That means that we address everything. We address emotional and mental health. We address physical health. We address financial health. We address all of those things that can impede or cause you to not be successful in your sobriety. All the while, your children are also there with you and you're getting parenting skills, you're getting life skills, all of those things. And so we have started our big fundraiser event. We've located a piece of property that we're trying to purchase. And so all of the fundraising that we're doing right now is going towards purchasing the land so that we can have our beautiful facility, which has been designed by Perkin and Wills, which is a world-renowned architectural design firm. They've donated their services to help us with our mission and vision of Success House and how great it could be so that we can have children succeeding and having an opportunity to reach their greatest potential because they're in a home that is healthy physically, mentally, emotionally, and financially. So we're asking for your help. We're asking that you donate to making Success House become this reality. You can look for us on our website, successhousertc.org. We're on Instagram, Success House RTC. We're on Facebook, Success House RTC, but we ask for your donations to give us a helping hand to ensure mothers that they can have a good start at sobriety that will last, and to ensure that children will have an opportunity, as all children deserve, to grow up in a home that's free from drug and alcohol abuse. So that's my soapbox.
I'm keep standing on it because I am so supportive of everything that you have done and are doing. And I want my viewers to have my back. I'm telling y'all, get on the chat. The chat has the information on, where to go, how to make those donations. And I'm going to check back with her. Now, y'all can't let me down. We come this far by faith. Don't let me down there. So make sure, guys, please go today. Log on to see what she's talking about, see the work that she's doing, and make a donation. I take it as a birthday gift. You want to give me something? Please. Brother Theo's birthday passed. If you would help us celebrate and be supportive of this endeavor, this project, because helping her helps us, right? And so we want you all to make a commitment today. Put a $ in the chat. Put a $ on Facebook. You don't have to tell me how much you're giving. Just let me know you're going to give. Please, please, please. Go ahead, Attorney Sessions.
And let me say this. Although, of course, we want your donations, but everybody may not be in a position to donate, but they are in a position to encourage others or to tell their family and friends. And you can go on Amazon Smile, right? Everybody loves to order something from Amazon every now and then, or some people like me all the time. But you can go on Amazon Smile and designate us as your charity. Nothing comes out of your pocket, but Amazon keeps a track with all the people that have designated and made purchases through Amazon. Awesome. And then they make a donation to Success House. We're also on the Kroger Rewards Card program. If you're a Kroger's customer and you frequently shop at Kroger's and you have their rewards card, you can go in online and you can designate Success House as your charity online as well. And then every time you buy groceries, Kroger's will make a donation to Success House. So there's so many different ways of giving. And so we appreciate any effort anybody makes, because really we want to impact these children for generations. We want the next generation. These little kids, they grow up and they become parents. We don't want them going in this cycle of drug and alcohol abuse. We want them to be able to support their kids and support other people and to help other people. We want these mothers to be able to learn how to pick their relationships, right? Pick their friendships and support themselves. Get off of this welfare roll. It's okay to be on welfare if you need it, okay? When you need it. But let's be self-sufficient. Let's
Yes.
learn some entrepreneurial skills, okay? It's people out there, they are making money. We've been in a pandemic. It's people learning how to make balloon bouquets, do funeral programs, make masks. I mean, all kinds of things. We're gonna have a full service beauty salon in there. We're gonna have an area where they'll learn interviewing skills and they'll get clothes. We're going to transport them, take them to court if they have to go to court. Our target population is not just women with open CPS cases, because that's how the idea came to me, but it's women on probation and parole. People get out of prison, or people, and they might have had children in prison, or they might have had children before they went to prison, and they need a helping hand. They know they have issues with sobriety, okay? We welcome them. We have homeless women, people that are, because of circumstances, they're
Yes.
homeless. They don't have anywhere to go. They need a chance.
Am I seeing dollar signs in the chat though? I need to see some dollar signs in the chat. I need to see some dollar signs on Facebook. We're gonna do this, attorney session. We're
Okay.
gonna do this.
Okay.
Yes.
Our
we're
mission
gonna
is
do this.
big, but it's a mission that involves everybody.
Yes,
It's a mission that
absolutely.
involves everybody.
Absolutely. And we are so happy to help. I was so excited to hear about this project that you are engaged in, because I feel like it is definitely a community effort. It is a community effort that needs to be behind you. And so I want to see some dollar signs, viewers. I need to see some dollar signs. I need you guys to go. She's made it so easy. In my household, we have all of that. Amazon, I got an Amazon clicker. She just clicks constantly. And I'm like, you know, that stuff not free, child. Right. That stuff not free. I pay for all that stuff you order. So yes, I have Kroger's, you know, we run the Kroger's for everything. So you've made it so easy. So please, please, please support, support, support. Yes, we need to. And
I appreciate everybody.
Yes.
And I really appreciate you, Attorney Manns. Qiana, you have a heart for our people. You putting yourself out there. This is phenomenal, what you're doing and what you've been doing. And when I tell you, she means what she does and she cares, she does. She's 100% genuine with that. Her care, the level of her earnestness to reach out and strive and do everything she can to help people is true. And it's,
yes, she is. Yes, she does.
I
Yes.
appreciate you guys. I do. And
you're
so,
awesome.
so if you guys will, for me, on behalf of Manns Law Office and the efforts that we have made to bring you the best, I'm telling you, I told you, we don't give you any talking heads. We give you people who, with boots on the ground, who working in the areas that they are giving you information about, real time, up to date information. And so on behalf of Manns Law Office, if you've got anything, you've received anything from these webinars that we've been able to bring to you, please, please go and support as much as you can for Success House to be successful. And so with that, ladies, I'm going to allow you to give your closing statements and information about where to reach you. If somebody wanted to retain your services, Attorney Bates and Attorney Curvey, how could they do so? Give all your information, because we want the people to call you. We want the people to retain you. And so could you give us some closing words and make sure that you give us your information, Attorney Curvey?
Hi, I'm Diane Curvey. If you want to reach me, I'm sorry, this cat is driving me nuts. If you want to reach me, my office number is 832-623-7998. I promise that the cat does not come to work with me. I would love to be of help to you. And just so that you know, I'm over here getting beat up, y'all. And just so that you know, I'm also running for judge of the 280 Judicial District Court, and I would love to have your support. Thank you so much.
Thank you. Attorney Bates?
Yes. Nicole Bates. You can reach me at 713-225-1300. Again, that number is 713-225-1300.
And attorney session, let's give out your information one more time, especially the information of how to donate for the Success House.
Yes, remember, Success House RTC. We're on Instagram at Success House RTC. We're on Facebook, Facebook/SuccessHouseRTC.com. We're on, our website is the main donation vehicle, www.successhousertc.org. You can donate right from the website, or you can send a check. I think the information we posted, the letter as to why donate, and that has our address on there if you feel more comfortable mailing in a check. And we also request that you designate us as your charity of choice on Amazon Smile, smile.amazon.com, and through your Kroger's Rewards Club as
And
well.
that information will also be posted on our website, and on the re-airing, you will be able to see. And I have people telling me they just donated. So hey, we getting you viewers. I appreciate it. We're getting it. We're seeing that you're putting your dollar signs in, that you're donating. So I definitely thank you all and appreciate you so much. Whatever you can give, please do. And Brother Theo, if you can give our information so we can close this out.
By all means. And I want to thank everybody for listening and our esteemed panelists. And also, if we need to reach our law offices, Sister Patricia is standing by always, every day, standing by Monday through Friday. And you can reach us at 713-589-6404. And before I leave, we need to, and I'm not going to sing, but happy birthday to Sister Qiana. Her birthday's coming up. I don't know how old she's going to be, even if I did know. I ain't
You don't
gonna
give
get
all
into
that
trouble.
business. I
No,
told you,
ma'am.
I done told the people too much about me already.
But happy birthday.
But
and
I thank you so much.
you know,
And to you,
and
sir.
we love you. And hey, I had my pen and pad, well, writing all of the notes and everything. I don't have a dog in this fight, but I definitely took a lot of notes for people who would ask us questions. But we thank each and every one of the panelists, and of course, thank you, the viewers. Happy birthday. May Allah bless each and every one of us for continued success.
Happy
Thank
birthday,
you.
guys.
Thank you. And follow us
birthday.
on Instagram. We're on all of the social media platforms. If you would like to post and share, please do. And we will definitely have this uploaded on our website. And until next time, we'll see you again with our next panel and our topic for November. You know, we try to come with you with the best and the brightest in our field. Thank you so much for joining us.
Thank you.
Goodbye.
Bye.